The handwritten card. That is where this ends and begins. A piece of cardstock with a seal of his own making, his name written in red ink calligraphy, a document he set on the table before his attorney had spoken a single word. He believed that card meant something. He believed, with the specific certainty of a person who has spent months building a world and has finally brought it into the room where he needed it most, that what was printed on it placed him beyond the reach of what I was about to do. He was wrong. And what I want to tell you is not that he was wrong. That part he eventually understood. What I want to tell you is what happened in the 3 hours between that card hitting the table and the moment the architecture he had built came apart. Because in those 3 hours, something occurred that I had not predicted and that changed what this case meant to me. Not the fraud, not the sentence, something else. Something that arrived in the 3rd hour when the performance stopped and a person appeared underneath it and asked me in plain language what he had actually done. My name is Isaiah Webb. I am a federal judge in Chicago. I am willing to name things that most people in this position prefer to leave unnamed. That is what this channel is for. If that matters to you, subscribe and hit the bell. This channel holds a line that a lot of other places have stopped holding, and it needs people willing to stay. And before we begin, I want to ask you something. Write in the comments the person this defendant could have been. One sentence. The version of him that existed before the ideology, before the card. What was available to him that he walked past on his way to that table? What I am about to tell you will change how you understand what happened in that room. He laughed. Not nervously. Not the short exhale of someone under pressure trying to hold themselves together. He laughed with satisfaction. The deep, settled satisfaction of a person who believes they have just said the thing that ends the conversation. He had just announced in my courtroom that he was a Moorish national, that he held no legal identity recognizable by the United States federal government, and that this court had no jurisdiction over the free sovereign man now standing before it. He smiled when he finished. He looked at me the way you look at someone you believe is about to realize they have made a mistake. I let him finish. And then I told him we were going to talk about what the law actually says. I have been on this bench for 4 years. In that time, I have presided over cases involving fraud, conspiracy, civil rights violations, and more than one proceeding where the weight of what I was about to decide required me to sit with it overnight before I could trust myself to deliver it correctly. I have had defendants cry. I have had defendants shout. I have had defendants produce documents, challenge my impartiality, and invoke constitutional provisions in ways that bore no resemblance to what those provisions contain. But I want to tell you about this case specifically, about this man, this argument, this room, and the thing that happened in it that I have thought about more than once since. Not because it was the most legally complex case I have handled, it was not, but because of what it revealed about a particular kind of certainty and about what happens when that certainty meets something it was not designed to handle, which is patience. He arrived with documentation. I want to be precise about this because the documentation matters to understanding what I was looking at when he walked in. He had a handwritten identification card. Not a copy of something official, handwritten, calligraphy actually, careful and deliberate, in red ink on cardstock that had been treated to look aged. It bore a seal of his own making, a title that ran to 3 lines, and a series of numbers meant to resemble official government identifiers. He set it on the table before his attorney had spoken a word. He set it there the way you set something down when you want the room to understand that you have arrived prepared. His attorney, for his part, looked at the table with the expression of a man who has been having a very long month. The man had introduced himself not by his legal name, but by a phrase, a series of words connected by colons, structured in the particular way that this specific ideology structures names to signal sovereignty. I will not repeat the phrase here because repeating it would suggest it has some bearing on how I addressed him in that proceeding, and it does not. I addressed him by his legal name throughout. Each time he corrected me. Each time I noted the correction for the record and continued. This is the first thing I want you to understand about this case. The performance was complete. He had done the reading. He had internalized the framework. He was not improvising. He had arrived with a coherent internal structure, a worldview in which the court I was sitting in was a corporate fiction, in which his legal birth certificate had enrolled him as chattel property of the United States government, and in which his assertion of Moorish national identity severed him entirely from that arrangement and placed him outside federal jurisdiction. He believed this. He was not performing belief. He had built this world carefully over months, and he had walked into my courtroom prepared to deploy it. What he had not prepared for was that I had read the same text he had. I want to tell you about that. Before this case came to trial, I spent 2 evenings reading the foundational documents of the Moorish sovereign movement, the original writings of Noble Drew Ali, the elaborations that developed in the 1980s and 1990s, the specific legal theories that practitioners have used in courts across this country for 30 years. I read the case law. I found every decision in the Seventh Circuit that had addressed these arguments. And I want to be honest with you about why I did this, not to prepare a rebuttal. I did not walk into that courtroom planning to debate him. I did it because I believed, and I still believe, that you cannot address an argument with the seriousness it deserves unless you have understood what it actually claims. He had built something. I owed it to the proceeding to understand what he had built before I explained where it failed to hold. What happened over the next 3 hours in that room, I have thought about many times since. Not because it was extraordinary, because of what it revealed. About this man, and about a certain kind of certainty that I have spent my career watching at close range. The certainty of a person who has found an architecture that explains everything, and who has never stood it next to the specific reality of a federal courtroom. The first moment that told me something important happened before I had asked a single substantive question. I opened the proceeding in the ordinary way, asking counsel to confirm their appearances for the record, asking whether the defendant understood the charges before him. His attorney began to speak. The defendant put his hand on his attorney's arm. He said, and I'm going to give you his exact words because exact words are what the record contains. I do not recognize the jurisdiction of this court over a sovereign Moorish national. I am here under duress, involuntarily, and under protest. I reserve all rights. I looked at him. I have developed over 4 years on this bench a particular quality of attention that I do not think I possessed before I took this job. The ability to receive a statement completely, without reacting to it, without the expression on my face suggesting to anyone in the room that I have already decided what the statement means. I looked at him the way I look at everything in that courtroom, with full attention and without announcement. I said, the court's jurisdiction is established by Article 3 of the United States Constitution and by 28 United States Code, Section 1331. Your recognition of that jurisdiction is not a prerequisite for its existence. I am going to ask you again whether you understand the charges before you. He repeated his declaration, nearly word for word. I noted for the record that the defendant had been advised of the court's jurisdictional basis and had declined to acknowledge it, and that the proceeding would continue accordingly. Then I turned to his attorney and asked the question. I want to tell you what I understood in that moment, because understanding it is the thing that made the rest of the day possible. What I understood was that he was waiting for a fight. The architecture he had built was designed for conflict, designed for a judge who would push back, argue, challenge his premises, give him the engagement that the ideology requires. The argument works best as a debate. It lives in the back and forth. If I had said the things that the situation seemed to invite, if I had allowed my frustration to be visible, if I had leaned forward and said this argument has been rejected by every court that has considered it, I would have given him exactly what he had walked in prepared for. He had answers for that judge. He did not have answers for a judge who simply defined the terms and moved on to the evidence. So I moved to the evidence. And the evidence, I want to be clear about this, was serious. Beneath the Sovereign Theater was a fraud case, a real one. Wire fraud charges arising from a scheme in which this man had used false corporate documents he had generated using the same ideology, the same pseudo-legal language, the same invented authorities, to extract a significant sum from people who had trusted him. He had approached them as a legal consultant. He had told them he could use his knowledge of Moorish sovereign law to clear their debts, remove their mortgages, resolve their legal problems. They had paid him. He had produced documents that looked official, that bore official-seeming seals, that made official-seeming claims. None of it had any legal effect. The debts remained, the mortgages remained, and the people who had paid him had no recourse, because the documents he had given them contained no real authority. I want to stay with that for a moment. He had built his sovereign framework not only to protect himself, he had built it as a product. He had sold it. The people who had come to him, and I am going to tell you something about these people, because they do not always appear in the way the public imagines, were not sophisticated actors trying to abuse the system. They were people in financial difficulty, people facing foreclosure, people with medical debt, People who had heard through the specific networks where this ideology circulates that there was a man who understood a kind of law that most lawyers don't know about, a law that could release them from the arrangements they were trapped in. They had paid him because they were desperate and because he was convincing. And he had taken their money and given them paper. This is the thing the elaborate courtroom performance had been built on top of. This is what the red ink identification card and the colon-separated sovereign name and the declaration about jurisdiction were covering. A man who had sold false hope to people who could not afford it. I looked at the evidence carefully. I always look at the evidence carefully. But I want to be honest with you about what I was looking for in this case specifically. What additional layer of attention the evidence required. I was looking for the question of whether he believed it, whether the ideology was a sincere conviction that had led him into conduct he did not understand was harmful, or whether the ideology was, at least in part, a tool, whether the sovereign framework was the origin of his behavior or its justification. What the evidence showed me was more complicated than either answer. He had started, as near as I could reconstruct from the record, as a genuine believer. The oldest documents in the government's evidence, messages from years before the conduct at issue, showed a man who had found this framework in a period of his own financial difficulty, who had applied it to his own situation with genuine faith, who had experienced it as a liberation. He had reorganized his understanding of his own legal existence around it. And then, at some point, the belief and the opportunity had become entangled in a way that I do not think he had ever clearly separated. The second development in that proceeding arrived at approximately 2 hours in. I had been walking through the government's evidence methodically, chart by chart, transaction by transaction. His attorney had been attempting, with considerable professionalism, to raise evidentiary objections where they could be raised. The defendant had been watching me with an attention I had not expected, not the combative attention of the morning, but something quieter, something closer to actual listening. At one point, I paused in my review of a particular exhibit, a document he had given to one of the victims, a woman who had been facing a foreclosure on a home she had lived in for 22 years. The document purported to be a notice to the mortgage servicer invoking Moorish national law to discharge the debt. It was formatted with great care. It had a table. It cited provisions that did not exist in any statute. It had his colon-separated sovereign name at the bottom with a thumbprint instead of a signature. The mortgage servicer had returned it unprocessed. The woman had lost the house 6 months later. I set the exhibit down. I did not say anything immediately. I looked at the document. I looked at him, and I said, "This document was given to a woman named," and I said her name, "in the representation that it would discharge her mortgage debt. I would like you to tell me what you understood this document to accomplish," he said carefully. "Under Moorish national law, a creditor operating under the corporate fiction of the United States has no lawful claim on a sovereign national." I said, "She is not a Moorish national. She was a homeowner facing foreclosure. What did you tell her this document would do for her?" There was a pause. He said, "I told her it would stop the foreclosure." I said, "Did it?" He did not answer. I said, "Did it stop the foreclosure?" He said, "No." I said, "And you knew at the time you gave her this document that federal courts and state courts alike had consistently held that documents of this type have no legal effect on mortgage obligations." His attorney began to stand. The defendant put his hand up, not toward the attorney, toward me. It was the first time in the entire proceeding that a gesture of his had been directed at something other than the performance. He said, "I believed it would work. I believed in it." I said, "I understand that. I am going to ask you to tell the court whether you also understood that no court in this jurisdiction had ever recognized this theory as a valid basis for discharging a debt." He was quiet for a long time, long enough that the room changed quality, the particular quality that rooms acquire when everyone present understands that a threshold is being crossed. He said, "I had read some of the cases." He had read the cases. "I want to tell you what I did with that. I did not say anything in response. I made a note. I moved to the next exhibit. But I want to tell you what I understood in that moment, because what I understood is the thing that determined the weight I gave the sentence I subsequently delivered. He had known. Not fully, not in the clean way that legal knowledge works, but he had known that the courts did not accept these arguments. He had read some of the cases. He had continued presenting these documents to people who did not know what he knew. He had continued taking money from people who believed him, who could not afford not to believe him. while knowing that the framework he was selling them had been tested in courts and had failed. That is not the same as knowing your product is worthless, but it is not the same as not knowing. The moment that changed everything, the unexpected thing, the thing I have thought about most, came near the end of the third hour. His attorney had finished his substantive arguments. I had considered them. I had addressed each one on the record, citing the relevant statute and the relevant case law, explaining precisely why each argument failed to establish the jurisdictional or substantive defense the defendant was seeking. It was painstaking work. I had prepared it carefully and I delivered it carefully, because I had decided early in this proceeding that this defendant was going to leave my courtroom having understood every reason his arguments did not hold. Not agreed with them, understood them. He was going to know exactly where the architecture broke. And then he asked a question. He raised his hand, in the courtroom way, not the courtroom performance way. A genuine request to speak. His attorney looked at him. I indicated he could address the court through his attorney, or if his attorney consented, directly. His attorney, who had been a professional throughout a very difficult day, said he had no objection. The defendant said, "What does the government say I actually did?" I looked at him, not with surprise, though I felt something in the neighborhood of it, with attention. I said, "The government charges that you knowingly engaged in a scheme to defraud, using wire communications, by falsely representing that documents you created and sold had legal effect in discharging debts, when you had reason to know that no court in this jurisdiction had recognized documents of that type as legally effective." He was quiet for a moment. Then he said, "I didn't know it was illegal." I am going to tell you something about that sentence. Not its legal implications, its human texture. He was not performing. He had stopped performing somewhere in that third hour, in a way I could not identify precisely but could not mistake. The colon-separated name was gone. The references to himself in the third person were gone. He was sitting in a federal courtroom, having spent 3 hours declaring that it had no power over him, and he was asking a genuine question about what he had done. I said, "That belief, if sincere, is a relevant consideration in this proceeding. But sincerity of belief in a legal theory does not provide a defense to fraud charges when you had reason to know the theory had been rejected by courts of law. The question the court must address is not whether you believed in the framework. It is whether you knew or should have known that the framework did not deliver what you told your clients it would deliver." He nodded. One nod, small, genuine. That is what I carried out of that room. I ruled. I found him guilty on the fraud charges. The evidence established beyond a reasonable doubt that he had represented to clients that documents he created had legal effect, that he had received payment for those documents, that the documents had no legal effect, and that he had at minimum reason to know that courts had consistently rejected the legal theories on which the documents relied. The sentence I delivered was 36 months, followed by supervised release, restitution to be calculated based on the amounts received from each victim. I want to tell you about the moment I said those words, because the moment had a specific weight that I want to account for. He did not react with defiance. He did not invoke his sovereign status again. He sat. I want to be precise about what I thought in the moment before I spoke the sentence. I thought about the woman whose house is gone, about the specific quality of desperation that leads a person to pay a man with a handwritten card in red ink because she believes he has access to a law that her bank does not know about. I thought about what it had cost her to sit across a table from him and believe, and I thought about him, about the person who had started as a genuine believer and had, somewhere along the way, stopped asking himself the question that would have changed everything, which is, what am I selling, and do I know it works? 36 months. He is living with that. So am I. I want to leave you with something specific because I believe this case contains something specific worth carrying. He had spent months building a world in which this court did not exist. What he discovered over 3 hours was that the court had not noticed his absence from it. The law does not require your recognition to be the law. He had believed his recognition, or its withholding, was a form of power. It was not. The law does not negotiate with the person who refuses to see it. It does not argue. It defines its terms, cites its authority, addresses the evidence, and delivers its ruling. His sovereignty was real inside the architecture he had built. Outside it, in the room where a federal judge was looking at a document given to a woman who lost her house, it was nothing. I think about that phrase. The law does not require your recognition to be the law. I think about it in contexts that have nothing to do with federal courts. In the ordinary moments where someone tells you that the rules don't apply to them, that your claim on their accountability is a fiction, that the arrangement they have decided to reject no longer exists. The architecture of avoidance is always elaborate. The performance is always complete. What it cannot survive is a patient, precise accounting of what actually happened. That phrase is what I am offering you today. The law does not require your recognition to be the law. Say it once a day for a week and see where it lands. See which moments in your own life it illuminates, which people, which arrangements, which performances you have been watching and wondering whether anyone was going to name what was underneath them. I want to know something specific from you. Have you ever been in a room, at work, in a family somewhere, where someone told you the rules didn't apply to them? Not in a legal sense necessarily. I mean the person who decided that what they had built or who they were exempted them from the consequences that applied to everyone else. Write it in the comments. Write what that cost, the specific thing it cost you or someone near you. I read every comment, not because I am required to, because what you write there is part of the record of what it is actually like to live in proximity to that kind of certainty. And that record matters. If what you heard today felt like something you have been waiting to hear someone say out loud, I would be glad to have you here. Subscribe. Hit the bell so you don't miss an episode. What I bring to this channel is the same thing I brought to that bench 4 years ago when I took the oath. I am going to tell you what I actually saw, what I actually decided, and what it actually cost. No more and no less. He walked into my courtroom having built a world where I did not exist. He walked out having heard for 3 hours the patient and specific explanation of why that world did not hold. The record reflects the ruling. She lost her house. That is what the record also reflects. And I do not want to close this without saying so plainly. The sentence I delivered cannot return what the people he deceived lost. 36 months in restitution are what the law can do. They are not the same thing as what was taken. I know that. The people who paid him know that better than I ever will. What I can tell you is that in that courtroom, on that day, the arrangement that existed, the one in which he was sovereign and the law was a fiction, was replaced on the permanent record with a different and more accurate one. That is what courts are for. Not everything, but that.